Welcome to Shooting Straight, MayOneF.com. I'm Frank Miniature, the editor-in-chief. The NRA is America's first freedom. Today we have the great pleasure again to sit down with Stephen Halbrook, constitutional attorney and author. Now, Steve, you're writing another feature for us. You wrote a feature for us after the Bruen decision came down, that awesome win for our freedom. And now it's been a year since that took place. And in that year, I've got a whole list here of, 30, 40 cases that are happening around the country, all because of Bruen and the changes that brought around historically. Now the courts have to actually apply historical when this happened, what were the laws at the time, to the cases. So things are being challenged from carrying California to bump stock stuff to, just the list goes on and on. So I'm curious, now that you look at this as a constitutional attorney and what's gone on, where's this going over the next year or two? And are you excited, or what have you seen over the last year? It's a big open-ended question, but this is a big open-ended time for our freedom.
Frank, it's good to be with you again, and it's incredible. It's so much is going on, it's difficult to keep up with it. Because what Bruen did was to tell the lower courts, and of course these were lower courts doing cases mostly in states that have bad gun laws, like the majority of states are fairly even-handed and reasonable. And so it's the usual suspect states, New York, California, and so on. And the first of all, the rule that Bruen set was, you look at the text of the Constitution. If you want to know whether a restriction is valid, is the activity within the parameters of the keeping and bearing of arms by the people. But the people means something, and it means, it does not include illegal aliens, but the American people is what that's referring to. And so if you're within that concept of the people, and you want to know whether a restriction might still be valid, you look back into history, the history at the founding in particular. And if you can find similar laws that existed then, or if you can find analogs that or analogies to those laws that are parallel to them, you might be able to justify a restriction, like no guns in courts. And we would never argue to the contrary, but that tradition goes back, that's a restriction that goes back since the dawn of having courts. Before firearms were even invented, obviously. The orders kept, there's protection, orders kept by the bailiffs or the sheriffs or whoever is in charge of security. So, what Bruen said too, that we don't allow laws that are outside the scope of the Second Amendment. In other words, laws that directly infringe on the bearing of arms, and there was nothing in our history of our founding that would countenance such a law.
Right, the first Congress that wrote the Bill of Rights, passed the Bill of Rights, and the states that ratified that Bill of Rights as the first 10 amendments into the Constitution, there was intent. There was an understanding then of what that meant. And that's what this court, the Supreme Court, in the Bruen case, told them to look back to with laws. Are they applicable to how things were and what the intent was of that part of the Bill of Rights?
Exactly. And there were several cities at the founding that had laws. You cannot just discharge firearms up in the air on New Year's Eve. Okay, that's a good analogy. That would cover the same kind of activity 365 days a year here in Indianapolis, for example. No problem with a law like that. But what did the court do when it rendered Bruen? It sent several cases back down to the lower courts, and they said no more what they call means-end scrutiny, where judges decide from their own arbitrary value judgments whether this is a good or a bad law. And so one of the cases they sent back went back to the Fourth Circuit, which had upheld the so-called assault weapon ban in the state of Maryland. There were two magazine cases that the court sent back, one of them from California, one I think from New Jersey. And so the Supreme Court said, re-examine your decisions in these cases in light of our decision today in Bruen. And they've had the argument in the Fourth Circuit about Maryland's ban. And, I don't predict what courts are going to do, but good luck finding an analog at the founding that would justify banning like the AR-15.
Well, common use protections is what we were talking about here. And when the Second Amendment was enacted, there were guns in common use. Now, the AR-15 is certainly in common use, with well over 20 million now owned by U.S. citizens. How can you then go about banning it when the Heller decision, McDonald decision, and the Bruen decision all protect guns that are in common use?
I'll take advantage of that topic to say my new book is America's Rifle, the Case for the AR-15, and it's got all the con law history you could want. But and then some of these magazine cases have gone back down. Like California says, well, magazine is not an arm; it's not within the scope of the Second Amendment. So those issues are bubbling up again. What else? There's the California handgun roster, the roster of not unsafe guns. They won't say it's a safe gun if it goes in their roster. It's not unsafe. And of course, they're trying to squeeze the handgun market out of existence. The only handguns on there still are 20-year-old models or before that, because they have the micro-stamping requirement. No handgun in the world is manufactured with micro-stamping technology. And then the mag safety feature, most people don't want that. Cops sure don't want it. And some other features like that, so you can't get on the list anymore. So the anti-gun people, they are assembling their experts, and their experts include people like Saul Cornell, a historian who's basically ridden the anti-gun wagon for decades now in his career. And they're saying things like, well, here's an analog. They had gun safety requirements, and in fact, in other cases, they're harking back to they disarmed African Americans, slaves. So we should be able to, so they could disarm what they consider to be dangerous people. And
racist laws, using those as excuses for modern day gun control.
Right, when the revolution was going on, the Patriots disarmed Tories. Well, hello, they were fighting each other and killing each other. They also took away the press, the Tory press, and the Tories tried to do the same thing back to them. But look, in wartime, or you want to use a precedent like slavery to justify a gun law. Now, those laws have been cited in connection with the following. After the Supreme Court in Bruen invalidated New York's carry law, the law that judges decide whether you can exercise the privilege of carrying a gun for self-defense. So New York came back. It's like the Empire Strikes Back. We're going to get the best of the Supreme Court, and they made it illegal for a person with a carry permit to carry in most places. And one of the worst parts of that was normally if somebody doesn't want you to carry a gun, like in commercial property, they need to have a sign up. And so what they did was to flip that rule and to say, well, only businesses that have a sign up inviting you to carry a gun, can you carry a gun into that establishment? And I'm talking about public places where the public is invited. I'm not talking about people's houses. And so it's a felony, even if you have a carry permit, to carry a gun into any place, any public place, unless there's a sign up inviting you. And how many businesses want to get involved in this horrible
That's the First Amendment
political
infringement. That's forced speech.
It's there's one of the cases that argues exactly that. And, but, in this age of canceling people and woke politics, who wants to have to put up a sign and get involved in these a political controversy? Mm-hmm. All you want to do is provide, you're a drugstore, you want to sell, and you want to help people with, what they need. You want to buy some aspirin, fine. We don't want to be making political statements on our signage, outside. So that case has been argued in the Second Circuit. We don't know what it's going to do yet. But going back to the California roster out there, two district judges have invalidated the California roster requirement, because basically it bans handguns. It bans handguns that are if the model is 20 years, not on the prior list where there's none on the list for 20 years now. So, and what that does is makes the public buy handguns that are less safe, because manufacturers are always making safety improvements and, improvements in the metal and all the different parts. And if there's a product defects, they're going to correct that. So you've got that. Then you've got the age issue, like 18 to 20. Can you get a permit to carry? Can you purchase a firearm? The 11th Circuit Court of Appeals upheld Florida's ban on buying a firearm if you're in that age group. And the thing about that issue is, when at the founding, you were required, if you were 18 to 35, you were required to buy a gun and to enroll in the militia if you were an able-bodied man. And so obviously there's no parallel to a ban of any kind in that age group. They encouraged you. In fact, some of the militia laws required you to arm yourself when you were 16 and not just 18. And we just had a Minnesota judge invalidate a Minnesota law that restricted the rights of 18 to 20-year-old people. And there's a Texas district judge who did the same recently. So there's a lot going on, and cases percolate. They go to courts of appeals. We get circuit conflicts, and at some point the Supreme Court will resolve some of these issues. There's also been some activity in terms of like the Federal Gun Control Act, some of the restrictions that it imposes. There's a court decision that invalidated the federal prohibition on buying a gun or receiving a new gun if you're under indictment. And the basis for that decision was you have a Second Amendment right. You're innocent until proven guilty, just being under indictment.
Due process, right.
And this came from Texas, and the judge said everybody knows that a grand jury would indict a taco. I mean, the usual joke is you could get a grand jury to indict a ham sandwich, but he changed it to a taco. It's a regional thing. And so that case is pending. There's actually a case from the U.S. Court of Appeals for the Fifth Circuit about if you are subject to a civil restraining order, you cannot have a gun. And the court in that case said, look, this is not a criminal procedure where you're found guilty of a crime beyond a reasonable doubt. This is just some judge issues this restraining order, maybe with, under the red flag concept, in fact, without your side even being presented. And by the way, that reminds me, I think there's 2 New York judges have invalidated that state's red flag law. Mm-hmm. And so we've got a mixed result. We've got courts, logically and in good faith applying the Bruen standards, and you have other courts that are bending over backwards to uphold the restrictions, no matter what they are, and resorting to historical examples like slavery, as we just discussed. And so these cases are going to percolate, and this is going on all over the country, really. I mean, with the civil cases that our side brings, magazine bans and so-called assault weapon bans, things like that, that's going on all over the place, coming from states. And by the way, when Bruen was decided, there were only 6 states with semi-automatic rifle bans. Later that week, the Delaware governor hadn't got the memo about Bruen, so he signed that state's ban. We now have a ban in Illinois. There's been some Second Amendment challenges to that. And then there's the state of Washington. It's just, maybe it's going to be signed today or tomorrow. I don't know when it's going to be signed, but there's a ban that's just passing there. It went through the House and the Senate's got to go back to the House. And so no matter what the Supreme Court says, you've got this massive resistance. Some states, that they just keep coming back. And no matter what the court says, we're gonna get over on you. and we're going to prevail in the long run. We're going to make things as hard as possible to own guns. We're going to look at your social media postings to
New York
decide,
State, right? Yeah.
decide whether you get a gun permit. I mean, what a First Amendment violation. And in fact, you have to tell us what they are. We're not, you can't prevent somebody from doing that on their own. I could look you up, just Google your name and see what kind of crazy stuff have you put out, Frank. I could be a licensing officer and do that even. But I couldn't hold it against you and issue and not
You
issue
see some pretty cool hunting photos and stuff, I imagine.
Yeah, right.
The right person might say that that's hateful or something else and ban me. It's true.
Right. I'm offended by these hunting photos. I mean, it's so offensive.
Well, to sum this up, we're in this incredibly important constitutional period, and your constitutional attorney, this is kind of an exciting time for you because this is also a Second Amendment time. Now, it worries me, though, as, okay, we had Heller and McDonald, now we've had Bruen. It worries me that our side will get complacent because there's just never a more important time than now as this is being defined through the court system, as it's percolating up, whether the Supreme Court takes it or not, but it's being defined, this right we have, as the courts work this out. We have to stay involved.
No question, but I maintain the constituency keeps growing, the gun-owning constituency. We know, maybe beginning before that, gun ownership's been going up for decades, and 2020 came around, we had COVID, we had the riots, and we had so much uncertainty, and we had all these new gun owners. I just hope they find ranges to go to and instruction to get, because that we need them to do that. But if you have politicians advocating, I want to incarcerate you for 5 years if you have something I object to, a feature on your rifle, like a conspicuously protruding pistol grip. I don't want to scare anybody here when I use those terms. I mean, they're so frightening.
No, meanwhile, a woke DA let somebody out who just did attempted murder or robbed somebody or other violent crime, they might just walk.
It's not a problem, and when you exercise your right to self-defense, we know from several cases around the country they're going to come at you and prosecute you. And so if you have the right to bear arms wouldn't do you much good if you couldn't defend yourself. And in fact, the Supreme Court has repeatedly stated that the central component of the Second Amendment is self-defense. And so, people need to be aware of what's going on. But I tell you what, I'm from Virginia, and in 2020 our legislature changed, and they were proposing a bill to ban many semi-automatic rifles, and there was like a huge influx of people trying to buy property in West Virginia if that had passed, and luckily it didn't pass. And we have, idiots sponsor this kind of stuff. The chief sponsor in the Virginia House of Delegates said, what's an assault weapon? It's one of those guns that you fire with all of your fingers. I mean, so he wants to put people in prison for something he is completely oblivious about. So the pendulum always swings back and forth, generally between freedom and slavery. It's a rule of history, an iron law of history. That'll continue. We have to keep fighting them in the courts and politically and otherwise. And they used to say, may the best man win. Well, I hope may freedom win. And, and all I can say is before Heller, we didn't have a solid Supreme Court decision on the issue. And it's in my wildest dreams when I got involved in this subject back in the 70s, and we were a number of young people, and we decided we're going to start writing law review articles and promoting this topic. And it really paid off in the long run. We had a lot of good fortune. And so it's where we've gotten since that time. It's just totally amazing to somebody
Thanks to so many people
shoes.
joining the NRA, getting behind cases that you litigate. So many of these cases are NRA-back cases around the country now post-Bruin. So we're in this incredible period fighting for our freedom, and we have to keep going. But what I'm hearing from you mostly, though, which is good to hear, is I think you're mostly positive about the direction we're going. It's a hard fight, but it feels like you feel good about it.
Yeah, I mean, nobody knew where this was going to go. I was sitting in the oral argument in the Supreme Court in the Heller case, And we all figured Kennedy was going to be the swing vote. Nobody could figure out which way is he going to go. And when he asked the lawyer for the District of Columbia, weren't our founders settlers who needed guns to protect themselves from criminals and Indians and grizzly bears? And I felt elated then because he thought he understood it's an individual right.
Well, I was up in the journalist part viewing the Heller case in the Supreme Court, and an AP reporter sitting right next to me when Justice Kennedy said that, she went, "Oh no."
Right. The anti-gun people sitting in the audience, their hearts sunk. But I like to use that kind of as a joke when I give presentations because there were no grizzly bears east of the Mississippi.
Right. So Steve, where can people find you, find your books and all that?
I have a website, stephenhalbrook.com, and you can just Google my name, Stephen Halbrook, America's Rifle, or the Right to Bear Arms, or Second Amendment. You'll find all kinds of stuff. You can read many law review articles, and you can buy books, and there you have it.
Thank you, Steve.
Thank you, Frank. Good to be here.